And you have been promoted to panelist.
Okay, can you hear me now?
You can. And
Perfect.
if we don't have any attendees, we're going to tape this anyhow as if it were live because there are people that are going through estate planning right now that I would like to get a copy of this video.
Okay.
We've got 3 minutes and I'm going to go get some spreadsheet work done, but I'll be back in 3 minutes promptly. If you can monitor for attendees
Okay.
and ping me when we hit the top of the hour, which is now 2 minutes. Okay, we're creeping up on the top of the hour. And in order to respect everyone's time, we're going to jump in and get started. 2 weeks ago, we had a conversation about taxes and small businesses. We had a couple of great guests on going over the tax credits that have been laid out in what's called the Secure Act and Secure Act 2.0 for pensions and benefits for business owners. Today, we're going to talk about something that's much more broad-based. And then in 2 weeks, we're going to go back to business owners and talk about benefits. But today, what we're going to talk about is primarily death. Everyone's favorite subject, I know, but death will come to each one of us. And the question is, should we make plans now or just wait and let the state that we live in decide what happens to our stuff if we die before we do any planning? And I think most people would agree that making plans now makes sense. But and this is a conversation between me and Don Jr. about this subject because he works with me here in the office. He sees many of our client plans. He works with clients. He has clients of his own. And this conversation is almost always how we start. And the question is estate planning really about death? And Don, what would you say about that?
Death is really just the trigger. It's what causes everything else to start happening. And when that starts happening, we get to see all of the results of your planning pretty much right away. And sometimes it's going to be something as simple as the family not knowing where the will is,
Right?
or it can be in some cases with larger families and lots of siblings, it can be people demanding pieces of the estate right away.
Right? Right? Because if you have a large family, especially a blended family, which in today's world is not uncommon, you have our kids, your kids, and my kids. Um, Not all of them are going to be on the same page with what you want. And more important, they may be in different financial places and they may be married with kids of their own. And they're looking and saying, okay, mom and dad had a lot of money. They died together in a terrible accident. Why can't I have my money right now?
Mhm.
And of course, the people that are trying to handle this, the people that are the ones that are expected to be the executors or administrators of the estate. And let's talk about that. If you don't have any plan at all, the state of Washington or Idaho or California or Massachusetts, wherever you live, they have a plan. Because you didn't have any paperwork planned, you actually have to have one of your family members petition the court to be appointed as administrator.
Hmm.
If you had a plan, someone would be appointed in that plan ahead of time as executor. So an executor executes the will and trust for the decedents. An administrator is basically appointed by the court to do the same thing, but instead of referring to the documents that you prepared, it refers to state law.
And of course, if you're dramatically unlucky, you have property in multiple states that you didn't prepare paperwork for, and now you've got to petition the court in every single state where it's going on.
And whoever's doing that petitioning takes on, I like $20 words, something called fiduciary liability. They're not only responsible to each of the beneficiaries that the state has decided or your documents have decided, meaning if I've got 3 kids and my plan is to give them each 3 equal shares, and the executor is the big sister who says, oh no, the other 2 aren't ready for this, I'm going to keep it all and I'll just dole it out over time, they're breaking the law and they can be sued by family members. And believe it or not, family members sue family members when there's a lot of money at stake.
Even when there's not a lot of money.
Now, there's that. So it can be argued that getting your will done is future-proofing your family.
Hmm.
I think a phrase I like is estate planning is clarity in a chaotic world. And I think anyone looking at the news today would agree it's a chaotic world.
Absolutely.
So when should you get your first will?
Personally, my thought is your very first will should be the day you turn 18. It should be one of those important milestone steps that you take. And most 18-year-olds are going to think, well, I don't own anything.
Right.
But
But
the reality is they do in fact own things. It can be their personal memorabilia and items. It can be a very small bank account. It can be a life insurance policy.
and arguably it should be, at least in most cases, that life insurance policy, maybe even bought for them by their parents before they turned 18. But remember, this is not only about death, but also about planning. Um, are 18-year-olds occasionally prone to accidents?
Oh, absolutely.
And if an 18-year-old ends up in the hospital and they're unconscious, can their parents go and take care of their financial affairs and tell the doctors what to do?
In theory, if they can, it's going to depend first on them going through whatever steps the state has.
Yeah, so they'd have to petition the court unless that 18-year-old had done his will and medical directives and medical powers of attorney, which are typical documents that are put together by the lawyers or the online platforms, and we'll talk about that later, as part of a package. And you should get the complete package, not just the will or just the trust. A trust is a great tool, and we'll talk a little bit about that, but it still needs a will because not everything belongs in a trust, and the will take care of that. And then there's the stuff that doesn't operate because of a will or a trust. It operates because of a contract. So you're 18, you've got a job, you have a few $100 in your 401k plan, you've got a insurance policy through work for $50,000. For your 401k plan and that insurance, you've got what's called a beneficiary. And that's a contract between you, the company, and the insurance carrier of the 401k plan. Does that go through the courts or the trust or the will, Don?
The only reason it would, actually take that back, the two reasons it would, is that the first one is the you forgot to actually fill out the beneficiary information.
Oh, yeah.
And the second one is the person that you left everything to is no longer alive.
And the third reason would be if you said in there, I want my estate to get it.
Oh, yeah, true.
So having a will, medical directive, and then deciding your beneficiaries. So the one that you pointed out that I think is interesting is what if I choose my twin brother who's also 18 and is just as ding-dongy as I am, and we're in a common accident, only he dies and I live. So he gets to give his stuff to me, right? But what if we both died and we had
Mhm.
crossed over to each other? Could they have said if we're both dead, or if my brother can't inherit, I can have my mom get this?
Yes.
What's
The,
that
the
called?
the beauty of the contracts with the banks and the investment firms is that they can get fairly complex. And so you can say you have a primary beneficiary, your brother in this case, and then you can have a contingent beneficiary, and that's just somebody that's on the list that so long as your brother is alive to receive the money, it goes there. If he's not alive, that's what the contingency is for, and it goes to that person. And in many organizations, you can put two, three, or even four levels of beneficiaries that are contingencies down the line.
And another thing you can do, and I don't want to dwell on it, is let's say you've got five brothers and they're all married with children. You can say if one of those brothers dies, their children inherit their portion, or I don't like his wife, so no, I'm not going to let her get hands on it. But at 18, you're not thinking like that.
Correct.
What's the next step in life that could trigger an update to your will and trust if you did it at 18 or cause you to get it because there's something new in your world? What would that be?
Usually it's marriage.
Yeah. Or in today's odd world, maybe just living together and having kids
Hmm.
because kids will change your life and you want to protect them, right?
And even more importantly, in that circumstance, there's a lot of spousal protections that are built in a lot of states for various things that will just make things automatically happen if for some reason you didn't have a will. If you don't have those spousal protections in place, that makes the will and medical directives even more important than they were.
Absolutely. And there's so many other things to talk about there. So if anyone in the audience is in that position, give us a call and we'll go deep into that. It's also a great time to get your first quality insurance review where you're getting that life insurance that will replace your human life value if you die or if your spouse dies or horrible to contemplate one of your kids dies. Okay, so we got our will, we got our life insurance, the kids are growing up. Then what's next? What would cause us to change our plan?
Well, in one of these scenarios, your spouse dies or you die and the spouse lives on.
Yeah. But also, for most people, what happens is they buy a house.
Oh, yeah.
And sometimes they might buy another house in another state. And you mentioned that at that point, it's probably really sensible to talk to an attorney about a trust, right?
It starts to get there, and it will depend, of course, on the state and the type of property that you have. And
Yeah,
it's the sort of thing
absolutely.
where you really want to get the lawyer involved that knows the state that you're putting that property in, because that can really change things. If you have Washington and Idaho, it's not terribly complex. If you throw California in the mix, suddenly it got really complicated.
And then throw New York in and have a lot of fun. All right. Another thing that might happen, in fact, is very common today, is I move jobs.
Hmm.
And that can cause a need to change the plans. But even more important, what if I start a business? Doesn't that complicate it even more?
Very much so, especially if you have employees, partners, you got to start thinking about the continuity of the business. And a lot of people don't think about that when they start a business. Usually, business owners start with a great idea and a lot of hope in their hearts, and they go out and they're doing things, and their focus is primarily on whatever that dream was of their great idea. It's not the paperwork that goes with the great idea.
Right. And yet the paperwork becomes the reality when you can't talk because you're disabled or dead.
Hmm.
The last place that you really want to think about getting legal help as opposed to doing it online is when you have elder care issues, special needs, or blended family dynamics that mine, yours, and ours program we talked about earlier,
Mm-hmm.
trying to navigate an online legal service for that dynamic probably is more complicated than um, you can even imagine. And if you get it wrong, you create massive fights. So that those circumstances, I highly recommend you find a good attorney. We've got some we recommend that you can sit down with. Sometimes you can blend online with lawyers, and we'll talk about that. But let's talk about documents. What are the key documents that you really need? Not want like a trust, but really need. Number one is a will. And all that does is when you die, if you die, and you will, it triggers who the guardians for your children will be and who gets what. What if you don't die? Then you need healthcare directives, powers of attorney, and they have to be special powers of attorney that are called durable or medical, and a living will that says, if I can't communicate what I want, here's what I want in advance, and something called a healthcare proxy, which says, and I'm going to appoint my oldest son to be my healthcare proxy so he can go in and explain to the doctors why they shouldn't do what they want to do or why they should do it. And they have the legal right to say, this is in writing and I'm the representative and I can talk to you. If you don't have
Mm-hmm.
those documents, too bad, so sad. Online options, digital options, there's dozens of them, probably hundreds. LegalZoom, Free Will, a lot of planners like Free Will, Quicken Willmaker. The one that we really like is out of San Diego called Trust and Wills. And they just have an enormous library of explanation articles and videos on complicated subjects to simple. And you can get either a will or a trust or both online. And then they have attorneys throughout the country that will, on Zoom, figuratively speaking, sit down and talk to you about what you did and why you might want to change it from this to that or the other thing. Why all across the country? Because every state has different laws.
Mm-hmm.
So that's the blended option I talked about. If you've got multiple states, complex families, or businesses, as much as I like trust and will, I would recommend sitting down with a very experienced business tax and will and trust attorney who's done this for years and has seen all of the things courts do and families do, so they can really help you navigate the magic words lawyers use. We call that legalese. Does that make
Mm-hmm.
sense?
Yep. And I'd even say that as you get to that level of complexity, normally I would say for most people, you have basically two times you really need to update the will. You have a life event that happens, or it's just been 4 or 5 years, and maybe it's time to look at it just to make sure that everything that you put in place a half decade ago is still the way you want things to work.
Yeah, absolutely. That's great. A great point, Don.
And
Uh,
when you have a business, that's when things can get complicated quickly because you may have a scenario where your business is in a certain type of tax status that can
yeah,
completely change the way that everything's going to work, like a partnership versus a C corp versus an S corp.
and we just had that conversation with our tax lawyer yesterday. And not only do you need a good lawyer involved, you need a if you have a partnership or a S corp, you've got to have a good tax prep firm that truly understands. And same thing if you've got a trust tax return, they can't just take the documents you give them. They've got to see the partnership agreement, the LLC operating agreement, if it's an S corp or a partnership return, or the trust agreement before they can even determine what kind of tax structure they're going to prepare for you. So you've got to have good legal advice when you get into those complex trust and corporate and partnership business arrangements. The other thing, though, to your every 4 to 5 years, every year Congress meets, and while the estate laws are state by state, the tax laws are federal and state, and sometimes, like in New York, county and city. They call them boroughs in New York, not counties, but they're counties. And you could have as many as 4 or 5 layers of taxation when you die.
Mhm.
And the United States has had 6 or 7 different estate tax or death tax regimes since 1776. There have been a few periods, 2010, where there was no estate tax. And I don't remember his name, but there was a billionaire who was in his 80s who died in 2010, zero estate tax.
Hmm.
That was really either good timing or not on his part. But for most of us, when we die, one of the things that executor administrator is going to have to do is test to see whether you need to file a federal and state death tax return or final return. And the answer, by the way, should be yes. Even if you don't have a lot, what it does is it locks the tax bucket for you so your spouse later on can use some of your tax credit. And I'm not going to get deep into the weeds on that,
Mhm.
but that's why you really want to have an understanding of why an attorney might be part of your process. So what's happened recently? We went from 600 and some odd $1,000 as your threshold for estate tax before the turn of the century to today. It's almost $25 million per couple that's exempt from estate tax on a federal level.
Mhm.
But Oregon says if you have more than $1 million, 1 million, and by the way, that's a pretty middle class number today. Anything above that's taxed. Washington says we like that, but we'll make it 2 million. They just raised that a little bit, but it's essentially 2 million. States like Idaho and most states say we're just going to follow the federal rules. So they don't tax you when you die. But that almost $25 million number is going to sunset this year if Congress doesn't act. And I have accountants, attorneys, insurance agents who tell me absolutely they're going to extend the Tax Cut and Jobs Act. Others say absolutely they're not going to be able to get it done and it's going to sunset. I don't know. But if you have a sunset, it drops back to about a $7 million threshold, which is still above most people's value. But we've got clients that are going to owe an estate tax based on that 7 million that won't on the current 25 million.
Mhm.
So it gets complicated. You need to talk to someone who understands it to determine whether or not that matters. But what you can't do or shouldn't do is just ignore it and say, I'll hope for the best. Because when you're dead, you can't change your mind. All right.
Mhm.
We got about 10 minutes left. Somewhere in the last 30 years, and I don't remember exactly when, we started doing things online that you just couldn't do online before. Things like doing a will, things like doing a lease. There was LegalZoom and Legal Rocket, and just one after another companies jumped out. And as I say, we like Trust and Wills out of San Diego. It's Trust and Will, singular, out of San Diego, but there's lots of choices. And today, those choices can be pretty good. And what they offer is simplicity, affordability, and accessibility. For under $500, you can get an online will for a married couple, and for under $700, an online trust, and probably a lot less than that. Here's what they don't really do well: strategic advice, legal nuance, and again, state by state legal nuance, and long-term trust management. Long-term trust management is important because you may become disabled, so you can't manage your own affairs. And when you die, you may have the intent of having a pool of money for the people you love managed in a way that they can't lose it, they can't get access to it except under certain rules, And if they're not good with money and people sue them, the people that sue them can't get money out of the trust.
Mhm.
So it depends on what you're trying to do. But if you have, for example, a family where there are a number of adults and they are borderline economic basket cases, but you love them and you want to make sure they're taken care of, long-term trust management is critical. Is it fair, Don, in your opinion, to saddle a family member with that obligation of managing assets for the benefit of possibly troubled family members?
Not if they didn't volunteer.
Yeah. And what happens if they die along the way?
Then somebody else has to do it.
Yeah. So I've changed my mind over the years. 30 years ago, I would have said always use family because they're not going to charge anything. Today, especially in a complex trust, my opinion is don't burden family unless they're already professionals in the space and have volunteered for it. You don't want to blindside them and wake up one day, you're dead, and your cousin's like, I never signed up for this, right?
Mhm.
I've come around to the idea of paying trust companies or CPAs. And let's talk about that. Do they all charge exactly the same way all the time?
No.
Okay. So there's three ways these trust structures can work. An attorney or a CPA can be hired to be the trustee, or a law firm or a CPA firm. I prefer the firm approach because that way, if your CPA or lawyer dies, they've got other replacements and they have professional ethics, responsibilities, and insurance. So if they goof, the family can get recovery.
Mhm.
Typically, CPAs and attorneys are going to charge you an hourly rate. And you might say, it's hundreds of dollars an hour. Yeah, but they don't work all the time. They might charge 3 hours a month or 3 hours every 3 months. Trust companies and bank trust departments, I'm not a big fan of bank trust departments, but we'll leave that for another conversation, will often charge either a flat fee negotiated in advance or a transaction fee. In other words, if they do something, send a check, I want $25. Send 10 checks, I want $250. Or a percentage of assets under management. So if they're managing a farm and an apartment, they're probably going to do transaction billing. If they're managing a stock portfolio, they're probably going to do a percentage of management. It's typically in today's world under 2%. 1.5%, 1% is very common, sometimes less than 1%. The advantage to that relationship is they're professionals, they have insurance, and they all have succession plans so that if they move on, if they sell, the company that buys them has to take over the agreement. So it provides more security. All right, as we wrap up, remember next week we're dark because it's summertime and we're taking some time off. The week after, we're going to be talking benefits. Let's talk myths and mistakes. So I'll give you the myth and you can tell me if it's true or false. Myth number one, I'm too young. Not really, but let's pretend I'm 18. I'm too young. I don't need a will.
You absolutely need a will. Even if it's just the fact that you have $500 in your bank account and a term life insurance policy that you didn't know about, because a lot of insurance company or a lot of companies that you go to work for at 18, they're going to have a group life insurance policy, and you may or may not get a paperwork packet to fill out there to put the beneficiary information in. You should, but that doesn't necessarily mean you did, and suddenly you actually have a little bit of an estate.
Yeah,
Or even you have your car insurance. Let's say your parents were really smart and they bought a really big policy on there and you end up in a significant accident that takes you out. Then there's actually a very large payout that needs to go somewhere.
absolutely. So let's do myth number two. It's really expensive.
In the worst case scenario, you can go to your local library and they'll have access to legal forms for the state that you're in, and you can do it for pretty much almost no cost. and the state may have a notary requirement, and that becomes the only cost you have. That's the absolute dirt cheap way of doing it, and it's almost always only appropriate when you're in that 18 to 21 range and have nothing significant going on.
Freewill.com does free wills,
Mm-hmm.
and uh, it has a charitable intent. If you've got a charitable intent, that might be a good option for someone that's young.
Yep.
How about this one? Yeah, I agree. I need one. I'll get around to it. I'll get to it later.
You know, the most depressing story that I think we have on that is the couple that got married and were driving along in their convertible, and they pulled up to a stop sign, and a tree fell over and landed on them and killed the husband, and the wife was alive.
Yeah, traumatized and terrorized. He was a financial professional friend of ours, and he was a newlywed, and he was going to get around to it, but he didn't. And she had to, in addition to being traumatized by the horrific death of her husband right in front of her and her near-death experience, she then had to hire lawyers and spend a lot more money than could have been done had they spent a little bit of money up front. Okay, so the last myth that I want to touch on as we get close to wrapping this half hour up is I just don't have enough to matter.
The reality is everybody pretty much owns something these days.
Even if
It,
it's just their own body.
hmm And if you don't have any instructions set up, then people are going to start asking questions and making decisions in ways that you had no idea they were planning on doing. And so just some very basic instructions can help, but I'll go back to even just those intermediate or larger clients for a second. Beyond the will, the trust, etc., take the time to have a box of documents that actually explains the tactical instructions of how to carry out the will. And it can be as
Also,
simple as a list of, you know, this is where the keys for the various bits of property are. This is all of the contracts that I have for the business.
how
This
about
is
digital assets?
That's another big one. Here's a list of all the passwords, or here's, in a sealed container, and this is one where you might actually have custody with a lawyer somewhere. Here's the master password for my password manager.
Yeah. Because today people have digital assets. They have their photo albums, their music, their movies, their books.
Hmm.
Often they're storing things like tax return data and deeds and identification in those online storage. And it's not easy to get access if you don't have the legal authority and the password. So Don, I think this has been a good 30-minute basics. I'm sure we'll get deeper into the weeds in a future edition, but thank you for your time today. We didn't have any questions from the audience, but I look forward to 2 weeks from now. Remember, we're dark next week. We're out of town. And in the meantime, stay organized and enjoy the summer.